But the cause argument is so obviously weak that this Court of Appeals had to eject it, eject. And now they're pretending that the trial court's real argument was all about the Fifth Amendment due process. It wasn't. So this whole notion, the entire heart here of this Court of Appeals argument that Lisa Cook should stay in her job, this Fifth Amendment due process claim to notice and a hearing, is premised on the falsehood that Lisa Cook has a property interest, that she's a baroness in American government, that she has a property interest to a principal officer job in the Article 2 executive branch. And that's not right. That's not what our Constitution provides. And because, in fact, and under law and under the Constitution, she cannot have a property interest in being a principal officer of the U.S., which this court ultimately has to acknowledge, and then they just wave it away. Because she doesn't have a property interest in being a principal officer, she cannot have a due process claim. This is a complete house of cards. All right, let's get to Katzus. And look how much more clearly, distinctly, in plain English, this guy writes than those other two clowns. The president removed Lisa Cook from her position as a governor of the Federal Reserve System based on apparent misrepresentations she made in applying for home mortgages. So he starts right off. The president, the Article 2 executive branch president, a principal officer, cause. I mean, this looks like a great answer. If this were a law school exam, this would be the start of a great answer. The district court, the unelected black-robed tyrannical inferior district trial court judge Gia Cobb, enjoined the Federal Reserve Board and the chairman from effectuating Cook's removal. It held that pre-appointment conduct, it happened before she was appointed, the mortgage fraud, of a federal officer cannot support for-cause removal from office. That argument was not discussed by the Court of Appeals. They completely did not want to talk about it. Why? Because it is asinine to argue that nothing Lisa Cook did before her appointment, if discovered afterwards, could qualify as cause for removal from office. She could have murdered children, cooked their organs, served them at a dinner party, and according to Judge Gia Cobb, as long as she did all that before she was on the Federal Reserve Board, that conduct could not be cause for her removal. That's how contemptible these DEI federal judges are. The trial judge also held that Cook enjoys a constitutionally protected property interest in her office. In my view, both arguments are mistaken, and the equitable balance tips in favor of Trump. So I would grant Trump's motion to leave Lisa Cook fired pending an appeal on the merits. The Federal Reserve Act creates a board of governors, 7 governors appointed by the president, confirmed by the Senate. So principal officers, Federal Reserve governors wield substantial power over the economy as a whole. They set interest rates primarily, set national interest rates. The consequences are trillions of dollars. Okay, so it's a big deal. Governors serve a 14-year term unless removed for cause by the president. And that's all it says. It doesn't define cause. It just says removed for cause by the president. In 2023, Biden nominated and the Senate confirmed Lisa Cook. In 2025, the director of the Federal Housing Finance Agency, Bill Pulte, that is, referred to the Department of Justice allegations that Cook committed mortgage fraud in 2021, 2 years before her appointment. According to the allegations, Cook obtained a couple $100,000 mortgage to purchase a property in Michigan that she labeled as her principal residence. A few weeks later, 2 weeks later, Cook secured a $500,000 mortgage for a property in Georgia. So Michigan and Georgia, which she also promised to use as her principal residence. Mortgages of a primary residence are typically eligible for lower interest rates than other mortgages. In light of these allegations, Trump removed Cook for cause. He determined that the allegations against Cook call into question her competence and trustworthy as a financial regulator. That is the notice part of due process, by the way. She's not entitled to due process here, but to say she didn't get notice is obviously a lie. Cook sued the Board of Governors of the Federal Reserve, not the president, because that might have raised separation of powers arguments against her. So she sued the Federal Reserve itself. She claimed the president lacked cause to remove her. She also claimed a constitutionally protected property interest in her position as a governor of the Federal Reserve Board, thus entitling her to due process prior to removal. She sought a temporary restraining order, and the district court issued a preliminary injunction, enjoined the board from effectuating her removal. The trial court of Giacab reasoned Cook was likely to succeed on both the "there is no cause" and "I have a property interest in this job" arguments. The court held that for-cause removal requirement does not permit removal for any misconduct committed before the officer was appointed. That's just insane. And on the due process claim, the court held that Cook had a constitutionally protected property interest in her office, entitling her to due process before removal. The government seeks a stay of that injunction, so they want to be allowed to have Lisa Cook fired while the whole case is argued on the merits, which of course will take months or years. Judge Katzus notes that as an appeals court, we consider 4 factors in deciding a motion for a stay. We've covered these 100 times. One is likelihood to win on the merits, to prevail. The second is irreparable harm. And then we have balance of the equities and the public interest. Applying these factors, Judge Katzus would grant the stay and allow Trump's firing of Lisa Cook. He says Trump has shown a strong likelihood that will succeed on both claims at issue. The cause is relevant, even if it took place prior to her being appointed, and she does not have a property interest in the position and therefore is not entitled to any due process claims. He writes, Lisa Cook first alleges that her removal violates the for-cause requirement of the Federal Reserve Act. The government does not challenge the constitutionality of that requirement. They're arguing cause. Trump is, in this case. So the only question presented is the meaning of for-cause. The act does not provide governors with a statutory cause of action to challenge their removals, nor does the Administrative Procedure Act afford a cause of action. A cause of action is an argument you're allowed to make in court to challenge actions by the president. The APA applies to agencies, but not to the president himself. Accordingly, to challenge her removal, Cook must satisfy the demanding standards for raising an ultra vires claim that Trump's action in removing her was simply unlawful on its face. Such a claim is essentially a Hail Mary pass that rarely succeeds. Among other things, Cook must show that her removal is the product of an extreme legal error and that she has no other means to seek judicial review. As to the first requirement, extreme legal error, only error that is patently a misconstruction of the act, that disregards a specific and unambiguous statutory directive, or that violates some specific command of a statute will support relief. We don't have anything like that here. For example, if the statute says that Lisa Cook can be fired for cause, and President Trump decided to fire her because she's obese, they might say, well, that's can't be cause here. That's got nothing to do with her ability or suitability for the job. This is not an athletic event. So that might be extreme legal error, firing her for her explosive. But of course, that's not what's happening here. She's in charge of monetary policy for the United States. You can't have a financial fraudster in that job. That should be clear to everybody, right? The error must be so extreme that one may view it as jurisdictional or nearly so. In my view, the view of Judge Katzus, Cook cannot show error at all, much less such an extreme error as to warrant correction through an ultra vires claim. Cook's claim turns on the meaning of the phrase for cause. On that question of statutory interpretation, our review is de novo. We're not bound by what the trial court decided. We read those words according to their ordinary, contemporary, common meaning at the time of their enactment. That would have been in 1913, included a for-cause removal protection. Congress repealed that requirement 20 years later in 1933, but put it back in 1935. In 1935, the meaning of for cause in the context of the power of removal was simply some cause other than the will or pleasure of the removing authority, that is, some cause relating to the conduct, ability, fitness, or competence of the officer. This meaning was also settled when it was first used in 1913, the first time for cause protection was put in for Federal Reserve governors. This broad definition gives the president more removal authority than other removal provisions imposed by Congress or reviewed by the Supreme Court. It affords the president broader authority than good cause requirement. because it doesn't say good. It only says for cause. It also gives the president more removal authority than a requirement of inefficiency, neglect of duty, or malfeasance in office, which was the for cause protections that Wilcox and Boyle had, that SCOTUS affirmed their firings by Trump without Trump having to give any cause at all. And this for cause standard for the Federal Reserve is even broader authority than what Trump had in Wilcox and Boyle, and the Supreme Court upheld Trump in Wilcox and Boyle, which happened months ago, weeks ago. The president plainly invoked a cause relating to Cook's conduct, ability, fitness, or competence. The allegations against Cook could constitute mortgage fraud if she acted knowingly, and that is a felony offense. Fraud is an excellent reason for removal, not merely a permissible reason. Even absent intentional misconduct, any misstatements in formal application for six-figure loans are at least concerning, and the president specifically concluded the allegations can't cast doubt on Cook's competence and trustworthiness as a financial regulator. That is plainly permissible cause. The district court of unelected black-robed tyrannical inferior district trial court Judge Gia Cobb took a different approach. It concluded that pre-appointment misconduct cannot satisfy the modest for cause requirement. Even Lisa Cook herself did not urge that position, and for good reason. Imagine a governor who amassed his great wealth and stellar reputation based on financial fraud, discovered only after he took office. They mean a Federal Reserve Board governor. Imagine a governor who is discovered to have bribed a senator to ensure confirmation. Or imagine a Federal Reserve governor who is discovered to have committed murder before taking office. Such pre-appointment acts clearly would relate to the conduct, ability, fitness, or competence of the officer for the office. That is enough for the government to succeed on the for cause claim. The unelected black-robed tyrannical inferior district trial court Judge Gia Cobb did not presume to review either the factual support for or motive behind the cause articulated by the president. She didn't even look at the facts of the mortgage fraud. She just said it happened before the appointment, so it just doesn't matter. None of these people will look at the facts of the mortgage fraud. You know why? Because if they had to review the facts, the mortgage fraud would be a felony conviction for Lisa Cook. It would be incontestable. Normally, courts do not look behind a facially valid justification to probe the mental states of the president or even cabinet officials, nor do they normally assess evidentiary sufficiency on ultra vires review. But those questions are not currently presented. On the for cause claim, the unelected black-robed tyrannical inferior district trial court judge rested its likelihood of success determination entirely on the legal proposition that pre-appointment conduct cannot support a for cause removal. As that position is untenable, the government is likely to succeed in appealing it. The government is also likely to succeed on Cook's procedural due process claim, that she has due process rights, that she has a property interest in executive authority delegated by the Article 2 executive branch president against his will. The first inquiry in every due process challenge is whether the plaintiff has been deprived of a protected interest in property or liberty. Cook's claim is that the Federal Reserve Act creates the relevant property interest to which the due process clause of the Fifth Amendment attaches. The Supreme Court has long held that public offices are mere agencies or trusts and not property. So you can't have a property interest in something that's not a property. In Taylor, the Supreme Court applied that principle to reject a due process claim resting on an alleged property interest in the governorship of the state of Kentucky. The court cited Crenshaw, which held that an officer appointed for a definite time or during good behavior had no vested interest or contract right in the office. Finally, the Supreme Court in Taylor concluded the nature of the relation of a public officer to the public is inconsistent with a property right. Cook, Lisa Cook, in claiming a property right, invokes more recent new property cases tracing to Roth and Goldberg from 1970. She invokes Cleveland Board of Education from 1985, which held that a state statute protecting civil service employees from removal absent malfeasance, misfeasance, malfeasance, or nonfeasance created a property right protected by due process. Loudermill has been extended to federal career appointees as well, based on removal protections under the Civil Service Reform Act. Cook, however, is no mere civil service employee who is part of the broad swath of the lesser functionaries in the government's workforce. She is a principal officer of the United States within the meaning of the Appointments Clause of the Constitution. And not just any officer, but a principal officer who must be appointed by the president with the advice and consent of the Senate. So this is the distinction between ordinary employees and principal officers that is critical to this analysis that neither the trial court of Giacab nor the majority in this Court of Appeals bothered to address at all. They just waved their hands. And the main difference constitutionally is that the janitors, the secretaries, the mid-level managers, they are not exercising independently the executive authority of the president. A principal officer is. Cook serves as a Federal Reserve governor, member of the Federal Open Board Committee, both of which wield significant power over the nation's economy. She is more akin to the governor of the Commonwealth of Kentucky, who the Supreme Court said did not have a property interest, than she is to the security guard in Loudermill or the career attorney in Esperagua. As a principal officer of the United States, she serves in a position of public trust that creates no property rights. And if there's no property right, there is no due process claim. My colleagues, Judge Katzus writes, meaning the majority, the two-judge majority here, acknowledge that principal officers of the U.S. generally have no property right in the offices they occupy. But they say Cook is different, because she is a most unusual principal officer, one who is not removable at will. You see the circular argument here? In my view, that consideration does not distinguish Taylor. After all, even at the time of Taylor, the governor of Kentucky had a state constitutional entitlement to serve for 4 years, and he could be removed from office only in the extremely unlikely event of impeachment. In that respect, his tenure was at least as secure of that of an appointed officer who may be removed for cause, and he had no property interest in his position. In any event, the employee property cases would not help Lisa Cook, even if they were extended to principal officers. These cases recognize an employee has some legitimate claim of entitlement and thus a property right. But as Judge Easterbrook has explained, if there is such a claim, we must ask, a claim in what? What particularly is the property in a public job? Is it the emoluments of the office, the official power of the office, or the honor of it all? Does one own a public office as private property? Of course not. Again, we don't have dukes and earls and barons. It's just like when we talk about Humphrey's executor, or we talk about Weiner, or we talk about Humphrey's Weiner. Right? Those were cases in which those are heads of federal agencies, independent federal agencies with for-cause termination protection. The presidents at the time fired them. They sued. They won. The Supreme Court said, yes, you're entitled to winning here. The president fired you wrongfully. But what did they get? What was their interest that was protected? It was not the job. It was not the forced delegation of executive authority. It was money. It was back pay. You don't have a right to governmental power. We don't have royalty in the U.S. Judge Katzus continues, the employee removal cases do not upend the common sense intuition that one does not have a property right to wield governmental powers in our democratic system of government. There is no royalty in America. For these reasons, Lisa Cook does not have a property interest in her position, so the government is likely to succeed in defending against her bullshit due process claim. The remaining factors, balance of the equities, which is kind of fairness, it's a squishy, the third of the 4 factors for a preliminary injunction. The last one is the public interest. And when the government is a party, the public interest and the balance of the equities, they merge together. So when the government is the party sought to be enjoined, the public interest and the balance of equities factors merge. So I consider them together, Judge Katzus writes. In cases involving the president's removal of principal officers, the government faces greater risk of harm from an order allowing a removed officer to continue exercising the executive power. In other words, the forced delegation of executive authority against the president's will is a greater harm to the government, to our constitutional order, than the harm to a wrongfully removed officer who's unable to perform their statutory duties. This is Trump v. Wilcox, folks. This is a decision from the Supreme Court from earlier this year. Katzus writes, that's why the Supreme Court has recently stayed, frozen, thrown out preliminary injunctions preventing the president from removing members of the National Labor Relations Board, the Merit Systems Protection Board, the Consumer Product Safety Commission, the Office of Independent Counsel, the National Trade Commission. The list goes on and on and on. Trump has won every one of these cases at the Supreme Court. Those cases involved removal without cause. But the harm to the government is surely magnified where the removal is based not on a mere presidential policy preference, but on serious accusations of misconduct that call into question an officer's confidence, competence, and trustworthiness. And although Wilcox did flag a distinct question whether the governors of the Federal Reserve could be removed at will, that bears only on an Article 2 question not presented here, because we have cause here. It does not suggest that the balancing of harm should be any different. Lisa Cook contends that her position as governor of the Federal Reserve System is singularly important in American government. All the more reason to remove a fraudster from that position. In Collins, the Supreme Court declined to peg the merits of its removal jurisprudence to an individualized assessment of the relative importance of agencies such as the Consumer Finance Protection Bureau and the Federal Housing Finance Agency. The court stressed the severe practical problems with making such comparative judgments. In other words, is the Article 3 judiciary supposed to be ranking the relative importance of independent federal agencies? Is that not ultimately a political question for the political branches of government? Article 1 legislative and Article 2 executive. The Article 3 judicial branch is supposed to be the apolitical branch of government, not making policy judgments, settling cases and controversies before it based on facts and law, not public policy preferences. Given those problems, we should also be reluctant to distinguish between, say, the Board of Governors of the Federal Reserve and the National Labor Relations Board in the equitable balancing aspect of our removal jurisprudence. Moreover, the Board of Governors no doubt is important, but that only heightens the government's interest in ensuring that its governors are competent and capable of projecting confidence into the markets. And in empowering the president to remove governors for cause, Congress has specifically assigned that task to the president, not to the courts. My colleagues suggest that the nature of Cook's claim diminishes the importance of the government interest at stake. They reason that a procedural due process claim would not disable the president from removing a governor, but only would require some adjudicatory process first, perhaps in theory. But if a governor could demand a constitutional entitlement to due process prior to her removal, she could also enlist the judiciary to review the adequacy of that process. Even with substantial expedition, judicial review can frustrate presidential action for months or even years, and that would enable a potentially compromised governor to engage in significant government action, such as voting on whether to adjust interest rates, which Lisa Cook says she must do tomorrow, Wednesday, tomorrow, or today. On Cook's side of the balance, nothing distinguishes this case from the interests of the removed officials in Wilcox and Boyle. The trial court flagged the loss of Cook's ability to serve in her high-ranking public servant role, but the same was true for those other officials, and yet the Supreme Court held that this did not outweigh the competing injuries to Trump. More to Article 2, I should say. Wrongfully removed federal officers generally may obtain their salary money through suits for back pay, like in Humphrey's executor. Thank you, Judge Katzus. Which further undercuts the need for enjoining the effect of a presidential removal order. For these reasons, I would grant the government stay motion. As my colleagues deny the motion, I respectfully dissent. So the interesting thing is when Lisa Cook today votes against cutting interest rates, a decision that will cost the United States people trillions of dollars, and tomorrow the Supreme Court says her firing was legitimate, does the Federal Reserve vote still count when they had an illegitimate governor voting? Inquiring minds want to know. Certainly I want to know.